Good morning, everyone. Welcome to our virtual workshop. This morning, we're going to be doing estate planning essentials and covering some of the core topics to get a good, solid foundation built for your estate plan. Obviously, we're living in very strange times right now, and each of us is having our own experiences with COVID-19, the closing of many businesses. We are operating at a skeleton staff level with 25% of our staff. That is essential to get our work done. And we want to make sure that our clients have access to solid legal representation while this crisis is still going on and beyond. So we're doing things, and as you'll hear today, we are fully operational to get estate planning done from the initial consultation all the way through to the document execution. Hang on one second, bear with me. But what we're going to be talking about today is estate planning, the essential documents, the core four as we call it. And that is a will, a power of attorney, a healthcare proxy, and a disposition of remains appointment. And we have all of those documents available to you in real time, so that's good. And we're going to talk also about some changes that have come into estate planning in 2020. On January 1, we got a major new law dealing with retirement accounts. We had a prior webinar where we discussed the Secure Act, and that's impacting us and our clients in terms of how individuals get to inherit an IRA or 401k or other type of retirement plan. We did a webinar, which you can find, which is on our website, and that webinar would allow you to get a full hour on the Secure Act. If you have an IRA and it is part of your estate plan, that is something that you really want to check out. We're going to talk a little bit about it today, but not in any great detail. We also have a state budget that is obviously, due to the COVID-19 crisis, in further distress. When we started this, it was in a position where the budget had a $6 billion shortfall in New York. A good portion of that is the Medicaid budget. And so the governor appointed a Medicaid redesign team. It was the second such team that had been appointed, so they called it MRT2. MRT2 made recommendations which made their way into the governor's budget. And amidst all of this crisis and pandemic, the budget passed with a number of changes and cuts to Medicaid eligibility, which are going to impact all of you. So, still not turning. So we're going to talk about estate planning during a crisis. We're going to have a separate webinar to talk about the Medicaid changes and the Medicaid cuts. Beth, what's changing the slides? What's advancing?
Right here.
Oh, back on here? Okay, we're working, we're functional. So these new rules are going to be covered in our seminar here. And the question may be, okay, why now? And right now we're getting calls, distress calls from clients every day who have loved ones going through the healthcare system. I happen to have a very close relative of mine in Los Angeles who is COVID positive, who's been going through a very, very difficult course. The communication in the healthcare system is extremely difficult. My relative had a healthcare proxy. And if we didn't have the healthcare proxy, communicating would have been virtually impossible because no one would have had that legal authority to communicate and express her wishes. And we're working very hard and praying for her to recover fully from the coronavirus. And that healthcare proxy has been a godsend because without it, again, you're in the dark. Communication is difficult enough in healthcare right now, let alone not having a healthcare proxy. So in these documents, you appoint decision makers to make decisions for you of a legal nature, a healthcare, and a financial nature. And we're also going to talk about your last will and testament, what happens to your assets upon your passing. So the goals of estate planning remain, and they remain consistent. They just have a bit more urgency now. We want to, again, appoint individuals to make decisions for us if we should have a situation, an illness or an accident or an injury, and we are still alive, to make decisions for us. And upon our death, we want to have decision makers to handle our estates, our property, and our loved ones, to make sure that they're protected when we're no longer here. A good portion of what we do as estate planning attorneys is try to protect assets and minimize tax. So we're going to talk a little bit about that and what the current concerns are. And again, we're going to be scheduling another webinar to talk about the Medicaid budget and the changes that are coming, because they are drastic and they're going to impact all of our clients. One thing that you need to know, even though the budget passed April 1, because of certain federal restrictions on implementing that budget, the new rules don't go into effect until October 1st. So there is still opportunity if you want to plan for Medicaid to do so. And finally, we want to make sure that our families, our children, grandchildren, our nieces, nephews, loved ones, charities, if that's our inclination, are going to receive the appropriate assets at the appropriate time with a minimum of cost, complexity, and tax. So we'll talk more about that as well as we go through the presentation. One thing that we're learning, because right now the courts are closed. So if you need access to probate, if you need to do anything with regard to an estate and a will, can't do it. Not until the courts reopen. We just got an email this morning from the New York State court system that they are going to start conferencing pending cases and doing things remotely by video, just as we're doing today. But to file a new probate proceeding right now is impossible. So what happens? What happens if someone dies with a will? Does that will have to go to court? A lot of people say no. But the facts are, yes. Probate, the definition, is the proving of the will. No will has validity, even if it's signed with two witnesses and formal and sealed in hot wax. It's not valid until it goes through the court, and the court process is called probate. And our surrogate judges, there's only one for every county. They're going to have a caseload when we reopen the courts that's going to be astronomical. So they'll be working through these probate petitions. Is it advantageous to not go through that? And the answer is yes. The other court that we have to talk about is guardianship court. Guardianship is the process, if you do not have proper planning done, whereby you have to go through a court proceeding, a full trial, a hearing. It's Article 81 of the Mental Hygiene Law. It's the guardianship statute. We do a lot of guardianship work for people that have not planned. And in almost every case, had they done proper planning, the guardianship wouldn't be necessary. So guardianship court appoints a guardian after a hearing with a court evaluator, possibly a court-appointed attorney, and it's highly public, intrusive on your life. It's hanging the family laundry out on the public clothesline, which is not where you want to be. And this is not just for the elderly. We do guardianships for people who have had accidents, illnesses, injuries, who have not planned, even at young ages. And it's the only remedy. And again, emergency guardianship proceedings we are still doing, but a standard guardianship, if there is one, but a routine guardianship cannot be brought. So it has to be brought on an emergency basis. It is full litigation, and it is costly. Probate, every will, again, must go through court. If someone tells you, oh, I have a will, it doesn't have to go to court, no, not true. Bad facts. Every will goes to court. It's the probate process. If you don't have a will, it's called intestacy, and the government will decide how your assets are going to pass. Again, it's a public process. There are opportunities very easily to challenge a will, and so we look for alternatives. We're going to talk about that once we cover our core four. The core four documents in an estate plan are a will, power of attorney, healthcare proxy, and disposition of remains appointment. Every client that comes through our office that does an estate plan gets these four documents. They may do further planning with trusts, but this core set of documents is something that you're going to have regardless of the balance of your plan. So let's unpack it and let's look at what these documents are. starting with a power of attorney. If I walk out, get in my car, get sideswiped on the way out of the driveway, and I lapse into a coma and I'm in a coma for a month, who runs my business? Who pays my bills? Who gets my bank account access to it? Who manages my investments? I have a power of attorney, and I've assigned that right to certain individuals to act on my behalf as my fiduciary. The power of attorney is a statutory document in New York. It used to be very, very simple. It changed in 2009 and went in our office from a 3-page document to a 16-page document. So doing the power of attorney on your own is possible but difficult because it does contain a lot of very nuanced legal decisions in the power of attorney document itself. One decision, the first one that you have to make, is choosing who represents you. Who's going to be the power of attorney on your behalf? Very often, if it's spouses, one spouse appoints the other. If they have children, very often, one or more of the children are the co- or alternate agents. And we want to make sure that we have adequate coverage and that regardless of whether someone is not available, we have backup for those people. In this document, in the power of attorney, you can appoint more than one agent. You can have co-agents. And those co-agents can have the ability to serve either jointly, where you would require them both to sign every document on your behalf, or they can have the authority to act independently. So if you have primary agents, it can be a single individual. It could be co-agents. You can have alternate agents and always should. The alternate agents, again, could be single individuals or it could be co-agents. You could have 2, you could have 3. We try not to go above 3 because it just becomes logistically difficult. Under the new document, under the new power of attorney put again in place in 2009, the agent must sign on the document, and they pledge on that signature an oath of office where they agree to act always in your best interest, to never commingle funds with yours, to follow your stated intent in your estate planning document so they can't go outside the bounds of your direction, to keep accurate records, and to account as power of attorney. So when your agent is signing on, they're agreeing to all of those things under the penalty of law. And so it is a powerful affidavit that they sign to be your agent, and you want to make sure it's the right person, someone you trust with the right financial acumen to do this on your behalf. And one of the other parts of the power of attorney now is called the statutory gifts rider. So the power of attorney really is in 2 halves, 2 separate documents. The basic power of attorney is just notarized, and you appoint your agent to pay bills, manage assets, do things like that. Then there's the rider, the gifts rider, which appoints your agent to make gifts and to create trusts and to do further planning on your behalf. So why would you want to give that kind of broad authority? Well, if I, again, get sideswiped on the way out of the driveway today, and I can't do any planning to try to protect my assets, to minimize taxes, to shift assets into appropriate trusts on my behalf, if I want my agent to be able to do that for me, then I have to have this statutory gifts rider. So we do recommend it in most cases, not every case, but most cases, and it is something that will protect you. And again, we have people that have a power of attorney that come to us after they have become incapacitated, and it is a durable power of attorney, which means it survives that incapacity, but it doesn't have the statutory gifts rider. Where does that put us? Back in court. Even though they had the power of attorney, we still have to go for guardianship to be able to do the protection of their assets and the trusts that will safeguard them and their loved ones while they are incapacitated and may need care. So we don't want to go to court, so make sure that you have carefully considered the power of attorney and done it properly, and that all of the authority needed to plan on your behalf is in there. The Healthcare Proxy, again, is a statutory document. You can download it off the Department of Health website, but we do a little bit more than that. In New York, there is also a document called a living will that is not statutory, but the living will have specific instructions to your agent, in particular with regard to end-of-life decision-making. So whatever your preferences are, And the pandemic has really made us look very, very closely at this. And do you want a ventilator? We've heard a lot about ventilators. Do we need 30,000? Do we need 4,000? What's the right number? Crises where they're running out of ventilators. Well, during this pandemic, the ventilator has been the way to get someone through the coronavirus for a 10-day period, say, and then to bring them off the ventilator and have their lungs pick back up. Is that the kind of treatment that you want? And for almost everyone, the answer is yes. So you have to make sure that you have enough flexibility in your document and that it's drafted properly so that appropriate measures can be taken. But if there is no reasonable hope of recovery, that your agent has the ability to withdraw life support when there is nothing that's going to be gained by the treatment. So in our healthcare proxy, we have added over the last year or so language to strengthen the resolve of the agent and to strengthen the legal authority of the agent. What we have found and what cases have shown us is that healthcare providers in some instances do not honor the wishes of the power of attorney. They do not honor the directions in the healthcare proxy. So we give very specific instruction now with regard to artificial life support, nutrition, hydration, but we also give the healthcare agent the ability to challenge decisions and denials so that they can in fact go and challenge the doctor or the hospital if they are not abiding by the wishes of the principal under the document. And that is a good thing. We have also tied it back to our power of attorney, and we have given the power of attorney the ability to finance those challenges, to use resources to finance the healthcare agent, to challenge medical providers who are not abiding by the wishes that are expressed in your document. So the power of attorney in the healthcare proxy we've modified over the last year or so to include those strengthening provisions to make sure your wishes are carried out. So in this pandemic, the real heroes are those frontline healthcare workers, and we salute them every day. They are out there, they're putting their lives literally on the line for the people that we love that are going into healthcare in need of treatment. And so in our office, and you can let all of your friends know who are doctors, nurses, working in hospitals on the front line, we will do a free healthcare proxy and power of attorney, which again can be executed by video teleconference right from a smartphone. We can do a video chat and we can execute documents, but we will do a free power of attorney and healthcare proxy for any frontline healthcare worker who is out there working for us. Another document, again, which has come somewhat into focus is a Disposition of Remains Appointment. So upon your passing, how is your body dealt with? How are your remains dealt with? What are your wishes with regard to burial, funeral, what funeral home, what cemetery, are you cremated, are you going to be buried, what services do you want, is it a military service? All of those things now can be put into a legal document. We don't see this document very often. Not many other law firms do it. We've been doing it now since the statute passed 12 years ago. It's been amazing, 12 years of this. And I can tell you, having done literally thousands of these, that people's wishes for the disposition of their remains go everywhere from cremate me and take my family to Ireland, and we're going to have a party, 2-day party at the pub, and I'm going to be sprinkled on the old family homestead in Ireland with financing for the party, all the way through to traditional burials with caskets, masses, and the normal funeral, wake, etc. But it's personal preference, and you can take control of that, appointing an agent and then giving them your specific instructions with regard to end-of-life decision-making. I just redid mine, and I won't tell you what's in it, but having heard people's suggestions, I have evolved my thinking on what I want to happen after I'm deceased. With the healthcare proxy and the Disposition of Remains Appointment, both statutes call for a single agent. Power of attorney, multiple agents. Healthcare proxy, Disposition of Remains, single agent, and that's because they don't want conflicting opinions where you get a deadlock where you appoint co-agents. So one at a time, but always, always, always appoint as many alternates on the document as you have available. We see a lot of people come to us that have done these documents as husband and wife, and they've appointed each other. And when they did it, their kids were minors. Now the kids are grown, but they're not in the documents. So go back, look at it, and if your children are of age and of maturity, put them on as alternates. Make sure that you include them all, single file, in the documents so that you have adequate coverage when the agent is called upon to act on your behalf. And finally, we have a will. This is the fourth document in our core four, and a will directs the distribution of your assets. It will appoint an executor on your behalf, a trustee for any trusts that you create in your will. If you have minor children, it will appoint a physical guardian until the child is 18 of those minor children, and you can create trusts under your will. We call them testamentary trusts. The will is a vital document and really needs to be there because you can't predict what circumstances are going to be at the time of your death. We draft them with many contingencies. So we put trusts in as contingent trusts. Should a beneficiary be a minor, we define that as under 25. Should a beneficiary have a disability and need Medicaid at the time they inherit, a special needs trust would be created on their behalf. So a will is a document that on its face seems very simple, but when you contemplate all of the contingencies that could happen between now and the day you die, it's going to be something that you're going to want to build that will with a lot of planning and a lot of power so that your executor and trustee can create solutions for the beneficiaries that you may not even contemplate. And a lot of times when we go through this, clients say, wow, I never thought about all of those possibilities. And you don't have to. That's our job. That's what we do. And so a will, a good solid will, is a good foundational document, and you want to make sure that you've covered all of these bases in the will. I mentioned earlier the one downside to a will is every will, I'll say it again, every will must go through probate to be effective. And the process is you petition the court, you submit affidavits of the witnesses, you submit waivers and consents, or if people won't waive and consent, if they're natural heirs, they have to get served with citation. You get a court date. Once that whole process has resolved, you get a certificate from the judge called a certificate of letters testamentary. And from the date of your death to the date you get that certificate, your assets are frozen. Nothing's going to happen. And so that certificate now, we can't predict. It was taking a month, 2 months, 3 months. We have a New York City office. We have 3 attorneys full-time in our Manhattan office. New York County probate before the crisis was a 4 to 5 month process just to get letters testamentary. Once the courts reopen, and we don't know when that's going to be, we anticipate that this backlog of cases that will be building up is going to really swamp the boat and overwhelm those courts. You can eliminate the necessity of probate by using a living trust. And we will have future webinars coming up May 5th, trust planning. So today was the core 4, the basics. We will be covering trust planning on May 5th, 11 a.m., how to set up a trust, what types of trust to use, and we'll be back. Hope you can join us. Let your friends know. We'll be doing these on a monthly basis, and for the Medicaid changes, that's such a drastic and new and novel subject, we will be scheduling that shortly. And you can always go to our website to see our upcoming events at pierrolaw.com events. Just to touch base on the Secure Act, I mentioned it earlier. The key thing to know is when you leave someone an IRA or 401k, any qualified retirement account, they now must take that account out over a 10-year period. Used to be you could stretch it over a lifetime, not the case anymore. So we are doing a lot of planning for clients that have IRAs and 401ks and want to maximize the value because we have income tax on every dollar coming out of that IRA. When it's forced out over 10 years, that means the government's getting paid. So there are things that you can do. And again, we have a webinar on our site, pierrolaw.com. You can go on and watch the webinar we did on the Secure Act, which talks about some of the planning alternatives for IRAs and retirement accounts. We have not covered estate tax planning today. the numbers. Federally, we have an $11,580,000 estate tax exemption. That means that every one of you right now, that also applies to gifts, can take out your checkbook, write a check for $11,580,000 and pay no tax. My children's names are Victoria, no, never mind. But the annual exclusion, people talk about this, it used to be $10,000, it's now $15,000. Is that really significant for most people when you have a lifetime exemption of $11,580,000? So you're free to gift. If you're under $11,580,000, you're free to gift. In New York, we have a different number. I'll get to the next slide. But remember, there's an election November. The Democratic proposals that we've seen so far call for a $3.5 million exemption and a $1 million gift tax exemption. So we will be following that extremely closely, as I'm sure all of you will, to see how that election impacts us. In New York, if you're watching from a New York State seat in your living room or your kitchen, in New York, we have a $5,850,000 estate tax exemption, but we have no gift tax. So you can still, don't worry, you can still write that $11,580,000 check and pay zero tax, both federal and New York. That is the lifetime exemption. In New York, no gift tax. The only thing to know, the nuance in New York, is that they put a little clawback in. So if you make a gift and you die within 3 years, in New York, that gift actually comes back into your estate. So Medicaid is something we're going to talk about in the next webinar, and we're going to be scheduling that shortly. But again, the $6 billion deficit, Lord knows what it is now, because revenues with nothing running are trickling down while expenses for healthcare are trickling up. We're going to look at this. They drastically reduced the benefits for home health care under Medicaid. Major, major changes. So stay tuned for our upcoming webinar on those Medicaid changes. And again, we are here, some of us. The rest of us are working virtually from home, just as many of you are. And we're available to handle your estate plans, to answer your questions, to serve you in any way that we can. One of the segments of our business that has become extremely busy is our care management. We have licensed professional social workers on staff, Nora Barato and Susan Vale, who are working with clients through the healthcare system. So if you have someone that gets hospitalized, or you need home health care, or you want to plan and have an assessment done as to what you could do if healthcare were needed, home health care, our care managers are available. They're working full-time, virtually, and they're available to answer your questions and to assist with any of that. So we have phone conferences available. We have video conferences available. We can serve you in a number of ways. As always, we're still on the air, be it remotely. No more in-studio life happens, but every Saturday morning at 11 o'clock, we break down the issues that we're discussing today and a number of other issues. Nora Barato and I did the show on this past Saturday. We've had a number of very interesting guests. Telemedicine is one of the bright spots that's helping through this pandemic. And we had the CEO of United Concierge Medicine on 3 weeks ago. And you can always get our podcasted shows. You can go back and listen to prior shows at lifehappensradio.net. If you have any specific questions, you can email us at info@pierrolaw.com. You can always call us. Our operators are available at 459-2100. I want to thank you for joining me today. I hope it was helpful. And we'll be back on May 5th with trust planning. And again, always check our website, pierrolaw.com. Go to the events tab, and you can get all of our future programs there. Thank you. Stay safe. Have a great day.